Good afternoon, ladies and gentlemen. My name's Peter Lowenstone. I'm the REIV's corporate solicitor, and I'd like to welcome you all this afternoon to our Power Hour series, which today will be devoted to the changes to the Sale of Land Act, Section 32 statement, the new vendor checklist, and changes to the Sale of Land public auction regulations. October the 1st, now only a short time away, it's going to be a red letter day for estate agents in Victoria, because on that day, which is a Wednesday, middle of the week, there'll be a new Section 32 regime, a new due diligence checklist, and there will be changes to our auction regulations. Let's make a start with the Section 32 statement. What's going to change, or what's changed? From a day-to-day operational point of view, I don't think you're going to notice a great deal of change in the paperwork that's provided to you by lawyers and conveyancers. But the paperwork will be reorganised, and very importantly, starting on the 1st of October, there will be only one vendor statement, not two. Starting on that date, you won't be having a vendor statement that you provide independently of the one that goes with the contract of sale. The obligation placed on you, or your vendor, and you via your vendor, is to provide the Section 32 statement to the purchaser before the purchaser signs a contract of sale. So, what's going to be in the new Section 32? You'll still find that there are financial matters like mortgages. You'll still find insurance details are to be provided if the vendor's insurance isn't to continue until settlement. You'll find there's things about land use, for example, easements, covenants and the like. You'll still find notices which have been served, fencing notices being a typical example. You'll still find building permits, owner-builder permits and building permits in the last 6 to 7 years. You'll still find owners' corporations, and I want to go into that in a bit more detail. You'll still find details about owners' corporations. And interestingly, the statement won't be saying to you anymore what services are connected to the property you are selling. It will be telling you what services are not connected. The thing that is important to note about the Section 32 is to get it signed as soon as possible. How many of you actually receive Section 32s from conveyancers or lawyers that are pre-signed when you get them? Well, the ones that are putting their hands up appear to be in a distinct minority. So it sounds as though to me, from what you're saying by a lack of forest of hands, is you're the ones that get the vendors to sign the 32. Is that correct? Plenty of nodding heads. Get the document signed ASAP. The new change to Section 32 is that a vendor can now sign a Section 32 by putting on it their electronic signature. So you can send an unsigned PDF, get the vendor to sign, and return it to you. Doesn't have to be signing in ink anymore. The requirement to provide the Section 32 signed is really vital. The other thing that is vital with this is the way you assemble the documents. How many of you receive documents other than by PDF email that are actually assembled for you? You don't have to do that. Still in a distinct minority. So am I right in saying the experience of most of you nowadays is that you receive the documents and you assemble them and get them signed? Plenty of nodding heads, right. The obligation is the vendor presents the buyer with a signed Section 32 before the buyer signs the contract. So the way you assemble things is important. If you've been in the habit of putting the Section 32 statement behind the contract, so the contract appears as the first signed document if I look at the assembled bundle, reverse that. Make sure the Section 32 is in front of the contract. So if any issue comes up about was it signed first or wasn't it, at least the documents are in the correct batting order, and you can say, well, it's logical it was signed first, it's the first document in the package. I mentioned a moment ago about owners' corporations. The changes to Section 32 recognise at long last that there are many, many inactive owners' corporations. So, from the point of view of speeding things up, avoiding delays, if you have an inactive owners' corporation, you're not obliged to provide the owners' corporation certificate. Now, this is quite important. What is an inactive owners' corporation? An inactive owners' corporation has to have met 3 tests. First test is in the last 15 months, it can't have held an AGM, can't have fixed fees, and didn't have insurance. So if you have your typical 2 or 3 lot suburban villa, strata plan, which has an owners' corporation, and everybody treats their unit as though it was entirely their own and the common property didn't exist, and no one meets and does anything, then you don't have to be worried anymore about providing an owners' corporation certificate. What about existing listings? So if you've got listings that exist now or you take on in September, it's very important that you get any Section 32 statements that are in files signed before the 1st of October. Because if you do that, you don't have to worry about tipping yourself into the new regime and having to provide a new 1 October Section 32 statement. And the transitional period will last until either the property is sold or the owner withdraws it from sale. Those 2 things happen, especially the latter, withdrawing from sale, then a fresh Section 32 statement will be required for that property. It's important to appreciate withdrawing from sale isn't your authority expiring and taking a new one, or your authority expiring and another agent stepping into the listing that you formerly had. It's all to do with withdrawing the property. It isn't tied to the length of your authority. Now, another watch point. You've got a pre-existing Section 32 statement. You sign up a contract subject to finance, for example. The property's withdrawn from sale because you think there's every opportunity that the purchaser will get their finance. It's off the market. If the finance isn't obtained and you have withdrawn the property, you'll then have to get a new Section 32 statement prepared. So, do not withdraw properties from sale where there is an existing Section 32 statement. Do not withdraw them, and make sure the buyer knows that the property won't be withdrawn from sale pending, for example, them obtaining finance or them having a pest and building inspection report or whatever. But you don't want to tip your vendor into the additional expense of a new Section 32 statement because the property's been withdrawn, and you don't want the delay that will inevitably occur if the property is withdrawn and then the sale falls over. So, what do I need to do in my office so far as Section 32s are concerned? Check all the files, make sure that there are no unsigned vendor's statements in existing sale files as at the 1st of October. Remember about withdrawing properties from sale, and that's basically the major things that you need to be aware of to be ready for the 1st of October with your Section 32 statements. The next thing I want to talk to you about is the due diligence checklist. What is it? It's basically an information statement in a generic form prepared by CAV. And in fact, this document comes in a CAV Director approved format. The format has been approved and you will have found it on your seat when you came in this afternoon. That's what it looks like. It's a single double-sided sheet of A4 paper with, as I've said, generic information. You'll see that the information that's in it includes things like urban living, owners' corporations, growth areas, flood and fire risks, rural properties, earth resource activity, soil and groundwater contamination, land boundaries, planning controls, safety, building permits, utilities and essential services, and buyers' rights. Who is it for? It's basically for three groups: vendors, yourselves as vendors' agents, and intending purchasers. Vendors who do their own selling have to provide this certificate. Those of you who are employed by vendors also have an obligation to provide the certificate. When do you have to provide it? When a property's offered for sale, you must provide this certificate in two ways. First of all, you need to provide a link to it in internet advertising on your own website. Now, CAV are going to provide a link which you can include in each property advertisement for residential, existing residential and vacant residential land. They're the only two instances where you need to use this statement. For example, to take something that's slightly off centre, you sell a farm, it has a residence. You need to provide on your internet advertising the link to the CAV due diligence checklist. I might add the CAV due diligence checklist is a little different to the one that you're holding in your hand at the moment. The CAV document will have other links in it which can take people to other sites. For example, it may take you to something to do with building regulations, that sort of thing. So it's a more comprehensive electronic document than the hard copy document that I've provided to you today. You also need to provide this document at your opens, and if you have private inspections, you need to provide it at the private inspections. You don't have to hand it to people, but it must be available on site. So you need to take that document that I've given you today and go back to the office and run many copies off, double-sided of course, in your photocopier and have them ready for the 1st of October. It's very important that everybody, and I mean everybody, on your sales team know the obligations surrounding this checklist. You must take it to your opens and have it available. If you have a private inspection, you must take it to the private inspections. What about existing listings? The due diligence checklist requirement does not apply to existing listings. So if you have a listing that's current on the 1st of October, which let's say you took on at the beginning of September, you do not have to provide the due diligence checklist for that listing, and you don't have to provide a link on your website to that listing. The only time that you may get caught up with pre-existing listings is if the property is withdrawn from sale and then comes back on the market. So it's important to keep that in mind. The obligation to provide the due diligence checklist is on the licensed estate agent. It isn't on, for example, personally an agent's representative or on a licensed estate agent who may be employed at your agency. So in other words, the obligation is likely in the vast majority of cases to be cast on the licence holder of your estate agent's licence, which in all likelihood is going to be a Pty Ltd company. That's where the obligation resides. Now remember, it has to be made available to any prospective purchaser. Do you have to include it in your portal advertising? In other words, you advertise with realestate.com, you advertise with Domain, you advertise with Real Estate View. You do not have to make the due diligence checklist available to prospective buyers via portal advertising. It's only your own website advertising that's caught up in this regime. The good thing about this due diligence checklist is that you don't have to monitor it and keep it up to date. CAV will do that for you. So don't create your own due diligence checklist and put it on your website. If you do that, you always run the risk that CAV suddenly have a brainwave and update their due diligence statement. If you've created your own, you'll be left with one that doesn't comply anymore. And please remember, use the approved director form which I've provided to you this afternoon. Do not paraphrase it because you think it's too wordy, and gee, I could fit it onto one page if I just chopped out this, this and this. Don't do it. You must use the director approved form. Now, let's move to the sale of land public auction regulations. Well, what's changed here? Fortunately, very little has changed indeed. Very little. You'll still have to, you'll still have to have your auction rules and your auction information on display 30 minutes at a minimum before you conduct your auction. The wording of the rules, all 4 sets, has not changed apart from the heading and dates and a few things like that. As far as the auction information is concerned, that's the Schedule 5 information that you're obliged to display. There has been minor tinkering with the wording, but really those changes are inconsequential. But once again, you'll need to provide the new forms. As far as the auctioneer's readout is concerned, the auctioneer announcements remain unchanged. They're still the ones that you've become accustomed to, and a no and the little brochure will remain the same, apart from updating to take into account the 2014 regulations. So what do I need to do in the office? First thing you need to do in the office is order the new sets of rules and the new information sheet. We're in the course of completing the costing of those now, and you'll soon be able to place an order with us for the sets of the new rules. Now, I need to mention to you that CAV are introducing an infringement regime for failure to comply with auction regulations and failure to comply with various sections of the Sale of Land Act. It's important you know about this because instead of an inspector or inspectors turning up at your auction and simply critiquing it and in all likelihood going away, if you don't have the correct documentation on display on and after 1st October, for example, you've forgotten the new rules. They're back at the office, but hey, it doesn't matter because I've got the old ones in the boot. And I listened to Peter Lowenstein and he said the wording hadn't changed, so there's nothing to worry about. You go to the site, you put everything on display, an inspector turns up, he looks at it, sees that in fact you're displaying the 2005 rules and the 2005 information, reaches into his hip pocket, brings out the infringement book and writes you out a ticket to the extent of approximately $1,800. $1,800 approx. If you don't provide a due diligence checklist and an inspector turns up to your open, and guess what? Everything's on display but the due diligence checklist. Out comes the book out of the hip pocket, $1,800, thanks. So it's a regime that actually has some teeth, and you need to be aware that it won't just be a gentle tut 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 anymore, could you please do that in future. It will be, here's your ticket, and could you please remember at your next auction to display the information that's required. There are lesser fines for lesser offences. For example, you forget to put up the auction information, but you've got everything else in place. There's a fine for that as well, but you'll be pleased to hear that's only about $148 in round figures. But I can assure you that if you get bitten, I can almost guarantee that you won't be repeating the performance more than once. Bit difficult to explain to the boss back at the office how you happen to come with a bill for $1,800 just for conducting an auction. I think that basically covers the matters that I wanted to talk to you about today.